Good morning. Please be seated. This is the time set for argument in the matter of State of Arizona versus Angelina John et al. And Adept bail bonds et al. Real parties in interest. We have two consolidated matters here, civil 17-0432 and -0433. Each side will have 20 minutes within which to present their argument here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have been through the record. We have read the briefs. We've conferenced the case. We are familiar with the underlying facts and procedural history, so please keep that in mind as you make your comments and arguments this morning. We're recording the proceedings, both by audio and video. The video will be available on YouTube in a matter of days after the argument's completed. But since we are recording, I'd appreciate if, as you approach the podium, you identify yourself and your client for us. With that, appellant may proceed.
Good morning, Your Honor. Clifford Shear appearing on behalf of the real parties in interest, the bondsman and the surety. The last time I was here in front of a panel of this court on another bond forfeiture matter, the first question that the panel said to me was, well, where do we draw the line? And I said something to the effect that, well, certainly not the entire $75,000 bond. Unfortunately, the court didn't accept that answer or that argument. But since that time, I have gotten help from an unlikely source, and that is the Supreme Court of Vermont. In 2015, faced a case not unlike this, and it's cited in my brief. It's called State versus Modelese. It's 2015 Vermont 81, and I can give you the Atlantic side if the court is interested. In any event, they went through a very lengthy analysis using essentially the state versus Old West bonding factors in coming to the conclusion that the proper measure for forfeiture of a bond was not the entire bond, as occurred in that case below, but rather the transportation costs to get a defendant back from the out-of-state jail, and in addition, some sort of determination, monetary determination, for the state's inconvenience or prejudice, which of course is an Old West bonding factor, but a state's inconvenience or prejudice because of a delayed trial, because of the amount of time that everybody had to wait. I pointed out in the court below that, assuming that was the determining factor or factors, that in this particular case there was no inconvenience or prejudice to the state, because what had happened was both defendants had entered into a plea agreement, and after they had returned, although it was not instantaneous.
It was a year later, wasn't it?
Oh, it was a year later. And by the time that the trial court got around to actually imposing the sentence, which was in fact consistent with the plea agreement terms. That took another year. But there were, in the interim, a number of continuances by the, underlying criminal court. So I argued to the bond division judge below. I said, look, they haven't charged them with, failure to appear. They haven't they haven't withdrawn the plea. Everything is going along fine. There's been absolutely no prejudice. So in this particular situation, I argued, both consistent with Model East, but also consistent with State versus Old West bonding, that since all the factors in Old West favored the appellants, that we should get a substantial mitigation. What happened was...
Well, Mr. Sherrod.
Yes.
I'm not sure all of the factors in Old West were in appellant's favor here. The willfulness of the defendant's violation of the appearance bond, can you really say that factor is in favor of the defendants?
Well, it's curious, Your Honor. In the findings of fact and conclusions of law that I requested that the judge, enter in this cause, the court on its own indicated that willfulness was not a factor that she was going to consider in this case. And so the first thing they teach you in law school is don't fight the facts. And the fact of the matter is the judge made that determination. I didn't necessarily think she was correct, but then I wasn't really thrilled with most all of her decision. And I certainly wasn't going to relitigate the issue if she said, well, under the circumstances, I'm not going to find that willfulness is a factor. So even though Your Honor makes an excellent point, and I don't argue with you, nevertheless, for purposes of our discussion, the trial court found no willfulness.
What about the inconvenience suffered by the state?
What about it? I'm not sure what inconvenience there was. And perhaps that's
sitting on the books for a year.
I don't argue the point with you, although, as I said, it's not like witnesses died or people left the jurisdiction that were going to testify.
Well,
in this case,
that would be prejudice.
I understand, but it didn't happen in this case. In this case, there was a, for want of a better term, pre-existing plea agreement that everyone had signed off on and which was eventually accepted by the court and entered, according to its terms.
Mr. Chair, can I ask you a really broad, basic question?
Absolutely, Your Honor.
And that question would be, in reading what the Superior Court did in this case, she clearly considered all of the Old West factors, and she, to the best of her ability, came to a resolution.
Okay.
On appeal, don't we give deference to the trial court? And how could we say she abused her discretion in this case? I mean, haven't you really just asked us to substitute our judgment for hers?
Well, the answers to your question is yes. Arizona law is to the effect that this court is obliged to try and uphold the decision, if possible. And yes.
We have to find she abused her discretion.
Yes. And it seems to me, now I attached as an exhibit to my opening brief a lengthy discussion a Court of Appeals case in California that went into great detail about what is abuse of discretion. I have cited the 2 Arizona cases that discuss abuse of discretion in bond matters, one of them being Old West, and the standard is you can't have wild, whimsical discretion, and the California case talks about that. Now, it seems to me that in a situation where a bondsman spends a year of his time hunting people all over the country and spends $41,000 to do it, and that the bond court says, well, gee, thank you very much for your trouble, okay, I'm forfeiting virtually I'm forfeiting $70,000 of the $100,000, and I clearly recognize that you spent $41,000. So for your trouble, you're $11,000 in the hole. You are $11,000 worse off than had you done nothing. And we thank you for your service, as it were. Okay, if that's
now, hold on. If you've done nothing, you'd have lost $100,000.
That's right. But as it sits, we lost 110. We spent 41 plus the 70. So, as I say, we're worse off by finding and returning these people to justice and, helping the state and all of that. And for our troubles, we're upside down on the case by $11,000. Now, if that isn't wild, whimsical discretion, I don't know what is. The court...
So I guess what you're saying is you would like us to come out with an order that says you always have to give the bonding company what they spent on their efforts to apprehend the individual.
Well, that's a start. Okay.
But that's not what Old West said.
Well, Old West doesn't say, that you're supposed to give a dollar for dollar credit, and I recognize that, and I put that in my brief. It does not say that. Another case that I cited in my brief was Clayton, which, like Old West, was a series of cases that were consolidated in the court below, full forfeitures, and on appeal, the Court of Appeals says, well, hey, you're the one that spent all this time looking for him. The state basically did nothing, as they did in this case. And we're not only going to give you dollar for dollar credit, but we're going to knock off another 95%. Okay? If the court truly wants to, reward bondsmen for their hard work, for, bringing defendants back to justice, it's not by penalizing them, paying for the privilege of doing that. It's by real mitigation, which Old West was set up to recognize, but didn't happen in this case.
So, Mr. Scher, what I'm hearing you say is you think we should write a decision which reweighs these factors in Old West, or simply discard Old West and create a new standard?
Well, as often as I have been here, okay, and seen some of the wild things the trial court judges in Arizona do, the answer to that question is yeah. Unfortunately so. You would think that Old West would have been good enough, but I can tell you from experience, sadly, it is not.
Well, this seems to me, I'm sorry, this seems to be as much a policy decision as a legal one, and I'm wondering, Mr. Scher, whether your remedy lies across the street with the legislature.
I am happy to live with decisions of the Court of Appeals. I don't know that getting some sort of legislative action, assuming that could be done, which in this day and age is, virtually impossible.
How about a rule petition?
I have filed them.
You have filed?
I have filed them. I'm on record as
Uh-oh,
2 or 3 of them. You betcha.
Well, you just told me that our bosses don't want to change the law.
Sorry, I meant the legislature.
a
No,
rule petition
I have
with the Supreme
filed 2 or 3 rule petitions on Criminal Rule 7.6. One of them was
And the Supreme Court has not been receptive to the change.
well, in 1997 they were, because they completely overhauled it. But the other times, not so much.
Have you filed one since after Old West was decided?
Yes,
And the Supreme Court was not receptive?
they were not receptive. Okay, I have 5 minutes and 40 seconds. I would like to reserve that, but I am happy to answer any questions that this court has at the moment.
All right. I think we'll hold those, Mr. Scherer. Thank you.
Okay, thank you very much.
Good morning, and good morning to Mr. Scheer. My name is Kim Felsen, and I represent the state of Arizona, the appellee in this matter. To start off, I listened closely to what Mr. Scheer just argued, and this has really been an interesting argument to prepare for before coming here today. It's very interesting to me because I know in working with Mr. Scheer through the years that his analysis always starts with the effect on the bonding company and the bondsman and the cost to them. But today, I feel like the inquiry being on this side is if the court was to adopt what Mr. Scheer is asking for, I would submit that that proposal would undercut the purpose of the bail. And what I mean by that is, excuse me, as officers of the court and as judges, we all know that the purpose of the bail is what amount a court looks at to determine is that amount a necessary amount that will ensure that the defendants will appear throughout the proceedings, on time, every proceeding. And that is designed to protect not only the public, but any victims in the case, if that's applicable. We also know that ARS 133967B talks about a person being on release and whether or not it's a bailable offense before trial. We also know that Article 2, Section 22 of the Arizona Constitution tells judges, look, these are the considerations that you can consider when you determine what is the amount of bond that is appropriate. Mr. Scheer looks at this as a punishment for the bonding companies. In other words, these bondsmen invested or incurred $41,000 of expense, and the lower court awarded roughly $30,000 back to them for their efforts. I would ask the court to consider that the bond is significant because it creates a risk of financial loss to the defendants if they abscond. In other words, they're put on notice, or they should be put on notice, that this is the amount of money on the line, and if you fail to appear in court for your hearing, you're going to inconvenience the court, the crime victims, the judge. The system is going to be disrupted if you abscond. So this amount is put in place, and we're going to look at those factors in those two sections of the law. In this case, he's asking you to undercut the purpose of that bail. Let's all imagine if these two defendants absconded for at least a year, but they were told, or it was floated through the jail, look, the only thing that you're going to suffer is you're going to potentially lose any cost to extradite you back to Maricopa County. We know that inmates are inmates, they're waiting for their cases to be resolved, and they talk in the jail settings frequently. Imagine how that would affect public safety and public policy if defendants were told, look, the only thing that you're going to potentially lose is a couple of $1,000s, even if you have a high bond, because the only thing in jeopardy is potential extradition costs or transportation costs. And it was very interesting to prep this argument today because Mr. Scheer, to my knowledge, argued the Old West bonding case, which we know gives courts very broad discretion to consider all relevant factors. And through his own admission today, he's telling the court, look, I want to alter that holding in some way, and I only want the bonding company to be responsible for costs to transport these defendants. If that was to happen, these defendants would presumably, it's logical to believe, abscond from the jurisdiction and simply take off because they know that there's really no repercussion for their leaving the jurisdiction and absconding. Sure, they'll lose some money, but the family member that put up the home or the car or the other collateral, they'd only have potentially a few $1,000s in extradition costs, whereas before we know Old West tells us that the entire bond is something that the court can consider. If there's no good cause for a defendant's failure to appear, and in these cases we know that both of these defendants, the court determined there was no good cause for their failure to appear, that the court had the authority to forfeit all of the bond, some of the bond, or none of the bond. And so it's very interesting because I know that Old West was a significant case for Mr. Scheer, and he argued it. So it just seems like if we all recognize that the bond serves to assure the appearance of the defendant in court on time, every hearing, if you were to alter it and do what he's asking, then there's a disincentive for the defendant, and he would abscond because really there's no financial loss. So it's okay, you can abscond, and when you're picked up and extradited from Las Vegas to Maricopa County, the only risk really is your $2,800 extradition charge. And I don't know if that's just. I don't know if that's just for members of the public. I don't know if that's effective in terms of public policy, which you would think the holding in Old West is directly tied to public policy because it talks about there's a whole multitude of factors that the courts can look at. And it even says in one point that we can't even describe to you all relevant factors. They do list, I believe, 7 factors with a description, including the 7th factor is any other mitigating or aggravating factors. But before that, they talk about how we can't provide every factor for you, but we're going to list 7.
Counsel, if I may.
Yes.
Given the broad discretion that Old West gives to a judge in determining the amount, isn't it pretty arbitrary to the judge's personal feelings? I mean, there's really, we say consider these factors, but it's really up to the judge, right?
Well, I think that yes. I mean, the court, it's very clear that they have broad discretion. But I think that if a judicial officer has a hearing or multiple hearings and is told basically all the relevant information that the bonding company and the surety and the indemnitor wish to present, if they weigh each factor or they're at least told every factor and, presumably they're taking notes, then they can make an informed decision, an educated decision as to what they think is appropriate.
Not to make up arguments for Mr. Scheer, but I was hearing that he was saying, well, how could you ever show an abuse of that discretion?
Yes, and I know that's an ongoing concern that he has because we've talked about issues like that. In my mind, an abuse of discretion could presumably be a judicial officer wanting to limit or restrict testimony. In other words, if someone came in and said, look, I'm the indemnitor, I put up my home, I'd like the opportunity to be heard, and for whatever reason, if the court says, look, I don't have time, or I simply don't want to hear from you. I mean, I think that could possibly be abusive, because if this person has standing to make a financial argument, that they could be impacted, and if the court doesn't hear that testimony, I mean, that certainly wasn't the issue in this case.
Well, how about a court refusing to consider one of these factors?
Well, I mean, that certainly could possibly be something that would be of concern. In this case,
Did the judge refuse to consider the willfulness of the defendant's violation of appearance bond?
well, in the minute entry, the court commissioner says that counsel concedes that factor 2 is not applicable and will not be considered by the court. And that is the willfulness of the defendant's violation of the appearance bond. And I wasn't sure why that was in place, because she would have heard how long the defendants were outside the court's jurisdiction. So
When she referred to counsel, was she referring to the bondsman, or was she referring to the state?
my belief is she was referring to the attorney for the bondsman. I don't know if she meant, when she says counsel, she's including both of us. But in my remarks to the court, I mean, I stressed the willfulness of their violation. So when the minute entry came out, to my memory and recollection, the willfulness is something that I did stress.
I know you gave an example of the court refusing to consider certain evidence or allow testimony in that, because the question is, well, at what point does the court's decision become arbitrary or whimsical,
Right.
as whatever that means? And I'm wondering if you have a similar example or input as to if we're looking at sort of the monetary aspects of this bond, whether how much is forfeited, how much is exonerated. Is there do you have ideas about how to consider that? At what point the court's decision on forfeiture or exoneration becomes arbitrary in terms of the amount as opposed to the evidence considered?
Well, I think it's a difficult question to answer. First of all, because we're not in the mind of the judicial officer. So whatever their thoughts are and impressions are, we don't have direct access to what they're thinking while they're on the bench and then later as they're memorializing it in the minute entry. I would submit that this court can have some reassurance that the holding or the decision would not be arbitrary or whimsical. And the reason why is we know that as judges and lawyers, none of us exist in a bubble. In other words, Mr. Scheer stresses constantly the financial impact to his clients, which that makes sense. That's his role as the advocate. Whereas my arguments tend to be more geared towards public policy, public safety, victim impact, if there is something of that nature, and whether any of those could be construed as aggravating factors under these factors under Old West. And so if you want to get away from the fear of having an arbitrary ruling or a whimsical decision, if you look at the transcript, the judicial officer got a broad amount of information. I mean, I felt comfortable in providing everything I wanted to say, and I'm of the impression that Mr. Scheer did as well. So I think that any argument or decision could be deemed or thought of as being arbitrary as an argument, but this is the system that we have to rely on, and there's nothing in the record to show that Mr. Scheer and his clients weren't given the opportunity to have, multiple continuances, to provide ongoing information to the court about the defendant's whereabouts. The extradition issue was given to the court. I mean, this case was continued multiple times. So I just think as a human being, we have to rely on good faith that these determinations weren't made arbitrary. I mean, if you look at the minute entry, the court even acknowledges that she is guided by State versus Old West, and she acknowledges that she has discretion. I mean, in order to resolve issues and resolve conflicts in court, I mean, we have to rely on the rulings of judicial officers.
Neither party, to my knowledge, in this appeal has argued that the court did not consider all of the factors under Old West. I mean, she may have rejected one, but she considered everything. And there's no allegation that she excluded evidence.
Yes, I mean,
So what we're left with is she comes down with a decision and she picks a number.
right.
The same judicial officer, a different judicial officer, on these same facts, could have picked another number, completely different than the number selected in this case.
Right.
And you would be standing before us today arguing that judicial officer had not abused their discretion, right?
I mean, I would, yes, Your Honor.
And we have a third judicial officer that would have heard the same facts, considered the same things, and would have picked another number. And so we would have had a range of numbers anywhere from maybe full exoneration to nothing. What is consistent about that picture?
Well, I think that what is consistent about it is that of those three judicial officers, each would have generated presumably a minute entry. Each would have been told the Old West factors and the site for that case for them to review and review. And by citing Old West and acknowledging that they have that broad discretion, it's just a balancing act. It's just what they feel is appropriate. And when you're in a business that is a very cash-intensive business like the bail bond industry, which these bondsmen are, you assume the risk. You assume the risk every time that you write a bond. As businessmen, they know that if that defendant fails to appear in court, that they could potentially lose the entire bond. Yes, they could have a judicial officer that gives them a partial forfeiture and a partial exoneration, but they could lose the entire bond. And that's the risk that you create when you're in a business that is very cash intensive, and the more money you make is generated by the number of bonds that you write. So the higher volume of bonds, the more money that you receive, presumably.
Counsel, when you argued this below, were you arguing to the court that both bonds should be entirely forfeited?
From my recollection with this appeal, because Mr. Scheer and I have done several of these appeals, I believe I argued a factor and I asked the court to weigh that factor against the amount that the bonding company incurred that's memorialized in the bondsman's affidavit. From my recollection, I don't think that I said that the entire amount should be forfeited. In fact, I don't think I took a position. I think I just said I want the court to be aware of this issue because I think that is relevant and compelling for the court to hear about this particular issue, and then weigh that against what Mr. Scheer was talking about with the three factors that the court considered for Mr. Scheer's argument. So I think that it would be very, very problematic to eliminate the discretion afforded under Old West because, frankly, we have nothing in its place. So I think in that respect, it would be irresponsible. But aside from that, my position regarding the conduct of the defendants stands that if people who are awaiting prosecution are told or get wind of the fact that the only thing that you're responsible for, if you warrant, is that you will have, a few $1,000s on transportation costs, I mean, that could really impact the conduct of defendants when they're on pretrial release, and it could affect public policy and affect public safety. And so again, when Mr. Scheer was arguing these factors and memorializing in his brief his argument, I was really taken aback that he would almost try to eliminate Old West because Again, that was the case that he argued. So for all these reasons that I've outlined, I would ask the court to affirm what the lower court did and affirm the lower court ruling.
All right, thank you, counsel.
Thank you.
Let's talk about public policy and public safety, okay? Assuming these people, the defendants, who weren't dangerous, but as I point out in my brief, and if the court reviews the record, are professional chiselers, professional swindlers. Assuming that they are a danger to public safety, they abscond. So, what does the public want? They want them found, okay? We found them, okay? That serves the public interest. A bondsman going out and finding absconding defendants serves the public safety and public interest. And as I point out in this case, for our trouble in preserving the public safety, we got to pay $11,000 out of our pocket to do that. That's not right. I'm sorry.
I have a feeling we're going to make the same point.
Did you make, I mean, you knew the risks involved, not you personally. They knew the risks involved.
Certainly.
It's a business model.
Oh,
You
yes.
understand that the more you lose, that you're just going to raise the bond cost for future individuals.
Yes, sorry.
You can get a judgment against the Miss John and Mr. Mitchell and try to collect against them.
I understand, but the idea that
Larry?
Pretty much. I think, Mr. Scheer, I mean, you do concede that your clients are in a position to require whatever security they think appropriate by the circumstances, and I'm sure they did in this case, and there's a remedy to change the playing field.
I am not so sure of that, but since it's not in the record, I'm not going to argue that point with you, but merely say, in my 44 years of practicing law, most of which representing bondsmen and surety, I've never seen a case like this, where the bondsman goes out, finds the absconding defendant, and for his trouble loses more than the face amount of the bond. Okay? That just is beyond belief. And as I say, if the state is concerned with its safety, you want to encourage bondsmen to go out and find them. That's the public policy. Yes. Oh.
At this point, I've just listened to the argument, and you've quoted a Vermont case, and you've quoted a California case, and you conceded that we must follow Old West. And we've agreed that it's an abuse of discretion standard. Other than that, am I missing part of your argument? I mean, the law in Arizona, Old West governs.
Yes,
correct?
you have not missed anything at all. Oh, well, in the sense that if I argue the same case in Vermont, same facts, same situation, whatever, I'm a genius and a hero to my clients. I cross the Mississippi, I come to the desert, and I'm a moron. Okay? Because my clients are now upside down for having done the right thing. Okay?
So they charge more in Arizona for their services than they do in Vermont.
That I don't know. But they have a better result. Ms. Felsen also talked about public policy, and the public policy, there's a number of public policies involved, and, Old West talks about it as well. Number one, and although this tragically has never been the law in Arizona, at least in a reported case, but it's all over the country, bail is not supposed to be a source of revenue to the state. Unfortunately, it often is in Arizona. The public policy is you want to encourage bail. You want people out to help prepare, and also not to run up a tab on the county for housing prisoners. You also want to encourage a diligent bondsman by mitigation of a full forfeiture of the bond, which Old West stands for.
Again, Mr. Scherer, the worst case scenario in this matter is a forfeiture of the entire bond plus the $41,000 that you spent trying to locate the defendant. That would have been the worst case scenario for your client?
True. That would have
Okay.
been the worst case scenario.
Best case scenario, exonerate the entire bond. And you've gotten something somewhere in the middle. Is that
Not nearly the middle. Okay, I would not have been so lathered had it been near the middle. In any event, I am thrilled to answer any further questions you have, but I see 4 zeros on my clock. So if the court has no more questions, I'll use Ms. Felson's minute and 13 seconds if you'd like, but otherwise, I will say thank you very much for your time.
Thank you, counsel. We appreciate the arguments here this morning presented, as well as the briefs in this matter. We'll take this under advisement, issue a written decision in due course. We're going to take a...
Not a memorandum decision, I hope something on the record, if I could put in my plea.
All right, thank you for that. We're going to take a brief recess to allow counsel for the next case to come forward and set up.